The issues involved in the John Doe 2 investigation. Would you defend how the Government Accountability Board, the state's election agency, has interpreted the state's campaign finance laws when it comes to limiting collaboration between candidates and groups that say they are independent?
Now, the current Attorney General had a conflict in this case, and so he cannot represent the Government Accountability Board because he also represents one of the judges involved in John Doe 2. He also said that the Government Accountability Board has taken a tenuous legal position relative to the statutes. Now, the GAB does have counsel. Special counsel has been appointed to represent them. They will not go unrepresented. However, laws in Wisconsin and anywhere are entitled to a presumption of constitutionality. The regulations created by a regulatory agency like the Government Accountability Board are not entitled to that same presumption. So when a regulatory agency goes outside the parameters of the law or outside the parameters of rules set by the courts in a decision, then you can't defend it. You have to advise them that you've gone beyond the standards, you've gone beyond the rules, and your position is not defensible.
And so your answer is no, you would not defend the GAB?
Not all of their decisions, no.
Susan Happ, same question. Would you defend how the Government Accountability Board has interpreted the state's campaign finance laws when it comes to limiting collaboration between candidates and groups that say they are independent?
I would, and that's because I don't see any constitutional infirmity in the law as it exists. You know, this law, simply put, is meant to prevent collaboration between these groups and to have openness and to make sure that we know that these outside groups aren't directly coordinating with the campaigns of the candidates who they are supporting. And so what I've just heard, which was different from the last debate, was that Brad was going to think about whether he would defend that law. And I hear him now saying that he would not defend that law, and that's different from saying that we have an obligation as the Attorney General to defend every single law. What's the constitutional infirmity to this law? It's meant to basically prevent corruptness in our political campaigns. And so I absolutely would defend this law that's meant to prevent that precise type of corruption.
Brad Schimel, I don't know if I can repeat this, but what is the constitutional infirmity of that law?
I'm not sure I follow my opponent's response there, because she said that I said I would not defend the law. And I believe the question was whether I would defend the GAB.
Accountability
right. I have not. If a law passed by our legislature has a presumption of constitutionality, and as Attorney General, you can count on me to defend the laws. I also will make sure that regulatory agencies don't go beyond the laws, the guidelines set by the statutes.
Susan Happ, you have 30 seconds if you want.
Thank you. To clarify, I mean, the lawsuit that we're talking about, though, is the heart of the John Doe. Some of these very same targets of the John Doe investigation have brought lawsuits against the Government Accountability Board and the key district attorney who is prosecuting that. And so now the state and Attorney General Van Hollen has said that he would not defend them in those lawsuits, but they are supporting and defending that law regarding campaign coordination.
Thank you.